Counsel, on record, your lordships, Chairman Honorable Maraga, ladyships, I will take up this discussion or the arguments or submissions from where we left, from where the discussion was, which was that following your ruling, your orders and directions on 1st of September.
Counsel, please remind us your name for the record.
My name is Lumalas Eunice.
Sorry?
Lumalas Eunice.
Lumalas.
Yes.
Proceed.
Thank you. I would like to just to briefly take you from where you left, the full stop after your last orders that elections be held in strict compliance of the Constitution, election laws and regulations. And what I'm going to just illustrate are a few irregularities or illegalities that are so fundamental and fatal that would make us not proceed with a different result other than nullification of this election. Lordships, after your orders on 1st of September, what happened is that the first and second respondent acted in total defiance and contempt by actually undertaking an election that was in complete abhorrence of the Constitution and all election laws and rules, as outlined in the petition and in the affidavits accompanying the petition and in oral submissions of fellow counsel. I will start by basically taking you very briefly, because of time, to what occurred on 5th of September this year. Now, if you look at volume 1 of the petitioner's evidence, you will find a gazette notice issued on 5th of September, which is number 37. Now, in that gazette notice, you will see that the first and second respondent are now moving forward after 1st of September. And what they're saying is that following the judgment, we are proceeding with elections on 17th. And what we are going to do is that there shall be no nominations, and this is very crucial for this case. There shall be no nominations for candidates participating in the fresh elections. And that, pursuant to the decision of the Supreme Court, we shall only be having 2 candidates. This they put in their gazette notice number 8751. Okay? And when you look at this same gazette notice, they are saying that pursuant to the decision of the Supreme Court in petition number 5 of 2013, that's why we are having 2 candidates only. So they go ahead and and proceed with the 2 candidates in clear understanding that we are having only 2 candidates, and we are using the law in place, which was the 2013 Supreme Court decision. Now, under this law, Your Honor, you will find that the term, lordships and ladyships, you'll find that the term fresh evidence has been used. And the legally fresh election, has been used. And this term was pursuant to the invitation of that court by the perpetual amicus curiae to try and, who is my former pupil master, to try and define and give a legal interpretation to what happens with the fresh elections. And what happens thereafter is the only law that we can find anywhere in the Republic of Kenya as we speak on the legal import of fresh elections and what happens after abandonment. You will not find this anywhere. You will not find this in the Constitution. You will not find it in any election laws. You'll find it in this judge-made law that when you look at the petitioners, where is it? I will just direct you briefly to our authority number 42, where that is defined. And the court poses. Suppose, however, that the candidate or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date. What happens thereafter, it is very clear, and this is the law that you'll find anywhere, is that the provisions of Article 138 ensue. And those provisions, under those provisions, we cannot escape nominations. Okay? The withdrawal or abandonment, because Senior Counsel Ngatia was trying to drag this honorable court into the array of politics by trying to distinguish the two. However, abandonment or withdrawal, so to speak, was occurred on 10th of October. When you look at the letter from the candidate who abandoned the election, and that is found in '49. You'll find it on page 49 of the authorities, volume 1 of the evidence of the first petitioner. This letter is of interest, and I would request that this honorable court, when it retires, has a look at the wording of the letter and of the press statement by the same party with respect to the elections. And they say very clearly that they are abandoning the process in pursuant to the 2013 presidential election. So there was clarity as to what law was applicable, and that law was the 2013 Raila decision. So they abandoned the process pursuant to that decision, and that is what they said, which is a legitimate expectation, having been guided by the IBC first and second respondent, that that is the actual law in place. Okay?
Now, Madam, can you say something about the express orders of the Supreme Court requiring elections? Can you just disappear and ignore the possibility of the election without coming back to the Supreme Court, when the Supreme Court has spoken very clearly and said in 2 months' time, ensure that elections take place? You come back to the Supreme Court, or you take your own decision and proceed?
What we are saying is that as a nation, we must accept to be bound by the law. Otherwise, even the suits we wear to come to the Supreme Court will mean nothing. Because when this, the Honorable Court in 2013, and I've directed you to where the authority is, stated that, and this is law, because it has been argued, and you will see it in the responses by the second and third respondent, that they are arguing that once a person withdraws, then the provisions of Section 52 of the Elections General Regulations, as amended in 2012, apply. Okay, but they don't apply, and that is why, if they applied, Senior Counsel would have gone to the next section after that, which is 53, which says, then declare the remaining candidates as the president-elect. Why didn't they do that? Because they knew those sections do not apply. Because what applied is where I've directed you, which is the provisions that flow after, under Article 183(8)(b, then ensue, which means that that other election would stand voided, and we start a fresh process. That is the law. Like I said, there's no other place you'll find that law. And therefore, once that had been done, the IEBC should either have stopped and started afresh, or maybe come for an advisory opinion before this honorable court. But they did not do that. You will find that Mr. Bwana Chebukati, maybe I should call him the first respondent, on 18th of October. When you look at his own affidavit at page 184, he goes on to make a statement, Your Lordships and Ladyship. What he does, he says that a candidate who has garnered more than over 6 million votes, at page 184 of his affidavit, withdraws from an election, which is an admission. Do we just go on as if nothing has happened? He says this 1 week after the withdrawal from a NASA presidential candidate.
So that you don't succeed in completely losing me, because I think you will need me, and because the lead counsel said exactly what you're saying, I'd like to know the point you are addressing. Are we dealing with illegalities, irregularities? What are we dealing with?
What is your
submission on?
This is still illegalities, but I was highlighting the legal import of abandonment and directing you to the evidence.
So why don't you restrict yourself to your subject? Forget about reference to counsel, please.
Well advised, Your Honor. So basically, I was highlighting an admission by the first respondent and an acknowledgement to that withdrawal, which then brings in the doctrine of estoppel. Other than that, Your Honor, I'd like you to just, maybe just in a minute's time, take you to the question of legitimate expectation. And the submission here is that the forceful insistence on having a candidate who was withdrawn on the ballot paper was actually misleading, and it is our submission that that is a violation, and a violation of the legitimate expectation of the people of Kenya and of the candidates who are participating in the election. And hence, part of the reasons we had the turnout we had. And we'll direct you to some authorities we have in our submissions. You will look at, where was that? Well, we have attached authorities on legitimate expectation, Your Honor. Sorry, Ladyships and Your Lordships. At page 43 of our authorities. You may have a look at that when you retire. The next issue and the next illegality we'll deal with is the question of participation. It's even the decision to use the ruling in the Mativo case to apply and include other candidates in the electoral process. That was in itself illegal because that ruling, 471 of 2017, was in personam. It only affected, when you look at the ruling, it only affected one candidate, who was Mr. Ekuru Okot, and did not affect all the other candidates. So what authority, what law was used to introduce the rest, to the rest? There was no law that was used. It was arbitrary and unlawful.
How does the inclusion of the others affect the election?
Now, when you look at that, which is where I was going next, there's the question of time to participate in elections. We have authorities to show that, including the case of BCJ, that an election process can only be valid when each process is given adequate time. So when you introduce candidates 2 days before closure of the time for campaigns, what are we doing? Are we really having a contest, an election? Are we giving the people of Kenya adequate time to choose and give them right information to pick a candidate of their choice? In my view, it is not a contest. You cannot bring other candidates 2-3 days before elections and another one, no period for election, and the different times, and then you call that an election. It is not an election. That is a submission. Perhaps just to finalize, because of time, I will deal with the issue of another illegality, which was having returning officers appointed on 12th by Gazette notice without having public participation, as is required under Section 3(2) and Article 10 of the Section 3(2) of the Election Petition General Rules 2012 and Article 10 of the Constitution. So that was unlawful. There was no public participation and no participation by political parties as is required by the law. Finally, we have misuse of public office and use of government resources in a way that influences the outcome of the election. So when you look at that, I will direct this Honorable Court in its own time to the affidavits of Joseph Abonga, which affidavit actually confirms what is in the petition of the petitioner, Mr. Njonjo Mwe, where it refers to utterances by one, the CS Matiangi. And I would really, even though we are hard-pressed, I would really request this honorable bench to have a look at the affidavit of Karanja Kibicho, which is very, very interesting and amusing to read. He does give us a lot of answers about what happened. He details intimidation to the court, which intimidation was not innocent. It was geared towards influencing the process we are in, which process is also part of the electoral circle. He details, when you look at paragraph 16, paragraph 26, he details what utterances were made. And Mr. Josephat Aboga actually places the CS to the scene of the utterances and it gives its input. Because of time, I'll direct you there. Yeah, so I think in general, all the violations as detailed should only guide this honorable court to have one question in their minds as you sit there, as you try to determine this petition. You all need to ask yourselves whether, looking at the totality of facts and law, was this election, in simple words, was this election undertaken on 26th of October similar to the one of 8th October in terms of compliance with the laws and the Constitution? Was it better? Was it worse? So that if you find that it was actually worse, looking at the petition and all the supporting documentation, including responses that are in support of the position, then you must be able to invalidate the election.
And if we find that it was actually better?
That is the question I'm asking, that you do after totality of evidence and facts, I suspect it was not.